That ought to handle it, Mrs. Sanders. If there are any termites who live through the treatment, I'll catch them next week. But you better get those structural cracks checked out.
Thanks for your help. It's been a nightmare ever since we moved here.
What else happened?
Well, when my company moved us here, we had to break the lease on our apartment. Now, our former landlord is keeping the security deposit and suing us for 5 months' rent. Then termites and structural damage and just...
Sounds pretty bad. You better get yourself a lawyer. My cousin had a good attorney when he was...
On this side, Judge Wapner will discuss the law as it relates to renting, buying, owning, and selling homes. Rent, buy, own, and sell. That's the order in which the average person deals with real estate. Since most of us become tenants before we become homeowners, Judge Wapner will first talk about renting from the perspective of both the tenant and the landlord. Then you'll hear about buying a home, with emphasis on the vital subject of financing and those 3 necessities of home ownership: insurance, taxes, and improvements. Finally, you'll learn some facts you should know when selling a home. This tape isn't meant to replace the necessary consultation with an attorney who specializes in real estate law. However, it will give you practical information about a sometimes confusing area of our everyday lives. Now, here's Judge Wapner.
Landlord-tenant relations have always been a source of stress and aggravation. Tension between landlord and tenant seems built into the relationship. It's a tension that's existed across cultures and across centuries. If you think about it, it's really pretty natural. Landlords want the most money they can get for the property they rent out. Tenants, on the other hand, want the most in service and amenities at the lowest possible price they can negotiate. Short of avoiding both roles entirely, what can you do to minimize friction and avoid unpleasantness? Here are 5 suggestions that I think will help make landlord-tenant relations, if not pleasant, at least tolerable. First, try to personalize the relationship. It's easier to mistreat or ignore a stranger or a corporation than it is to ignore someone that you know. If you know your landlord personally, you're more likely to make an extra effort to pay on time, observe the rules, and leave the place clean when you move out. If you're the landlord and know your tenant personally, you're more likely to make repairs quickly, bend the rules when desirable, and refund deposits promptly. Make knowing your opposite in the landlord-tenant relationship a priority in deciding which residence or tenant to select. Ask yourself these questions. Just who will I be dealing with? Is it someone I can like or can at least learn to respect and trust? If you're a prospective tenant, you'll want to be particularly careful if you're considering renting in a large apartment building or one managed by someone other than the owner. The opportunity for a personal relationship in this situation is considerably diminished. If you're a landlord, think long and hard about renting to someone who has a reputation of being late with the rent or who moved out of a previous place and left it in a mess. Which leads to my second point. Do your homework. Whether you're choosing a vacation rental at the beach or a permanent residence, the more you know about your landlord and the property you're about to rent, the better position you're in to make a good decision. So do some research. Talk to the folks who'll be your neighbors. Talk to the maintenance people. Turn the tables on the landlord. You ask for references. Visit at different times of the day. Also, take a good look at the neighborhood and decide if you'll be happy raising your kids there, inviting your friends to visit, or just walking around the block. The more information you collect before you sign a lease, the better your chance of finding a place you'll enjoy having as your home. Good landlords have learned that the more they know about their prospective renters, the better their chances of getting reliable tenants. They understand that getting the right tenant is well worth the effort. As a tenant, you should feel the same way about choosing your prospective landlord. My third suggestion for improving landlord-tenant relations is this. Explain your needs and expectations clearly to your prospective landlord before you sign the lease. While even perfect communication wouldn't eliminate all friction between landlords and tenants, or even between fellow tenants, clear communication can go a long way toward preventing many misunderstandings. To communicate effectively, you need to really consider the things that are most important to you about renting a home. Will it bother you if the neighbors play their stereos at top volume and party all night long? Will you mind if they're allowed to fix their cars in the parking lot? If you need extra storage space, is it available? And if it is, how secure is it? Will you have to pay extra for it? You'll do yourself a favor by asking the right questions before you agree to become a tenant. Number 4, get everything in writing. One excellent way to test whether a landlord is willing to treat you as a person rather than as a number is to request a change in the printed language of a standardized lease. If you take the time to read such a lease and any accompanying rules and regulations before you sign it, and you should, you may find at least one condition specified in the lease you think's unfair or that doesn't reflect your particular situation. If the landlord can't justify it and refuses to change it, that's a good indication of the treatment you'll get as a tenant. Go elsewhere if you have a choice. If you don't, at least you're forewarned. It's not difficult to get a term changed just because it's part of a form lease. All you have to do is to cross out the offending term and then have both of you initial the change. And if you need a substitute or additional term, you can usually just write it on the form lease and initial it. Landlords tend to load up their leases with unbalanced terms because they think they're protecting themselves. It's usually counterproductive. If the tenants don't understand the terms or can't realistically comply, the harsh terms create misunderstandings and bad feelings. This is particularly true where verbal promises or explanations are inconsistent with the written lease, or where the terms of the lease aren't the same for all tenants. Smart landlords keep their leases reasonable and balanced, and spend their energies finding good tenants rather than protecting themselves from bad ones. Smart tenants make sure they have a lawyer explain any lease terms they don't understand before they sign. My 5th suggestion for maintaining pleasant tenant-landlord relations is this. Keep the communication lines open. Open communication between landlord and tenant helps build trust and respect, nips potential problems in the bud, and smooths friction. Neither side benefits when misunderstandings fester or resentments build. Frequent communication keeps each concern from becoming a big deal. I encourage you to raise your concerns immediately and politely. Assume the goodwill and good intentions of the other party. I found that people have an amazing ability to adjust their conduct to meet the expectations of others.
Let's take a few minutes to discuss some of the common problems you may face as a renter. These include security deposits, subleasing, discrimination, breaking the lease, and eviction. In every instance, you need to know what your legal rights are, whether you're the landlord or the renter. First, there's the question of security deposits. A security deposit protects a landlord to some degree from tenants who move out early, get evicted for not paying rent, or damage the property.
Security deposits cause problems when the parties aren't clear about what they're for and under what conditions they may be used, or when the landlord tries to keep the deposit after a tenant who's paid all the rent moves out. Be sure your lease is clear about your deposit. Most leases say that the deposit may not be applied by the tenant toward the last month's rent. I think it's a good idea to have the deposit be an amount different from the monthly rent to help everyone understand that it's not an advance rent payment. Cleaning fees, key deposits, application fees, and similar items should be clearly identified and described. A deposit is, by definition, refundable. Be sure the conditions for getting yours refunded are clearly spelled out. Some states have laws that limit the amount landlords may ask for as a deposit. Many require deposits to be kept in a separate bank account, and a few require that the tenant get the interest earned by the deposit. Some of the restrictions apply only to apartments with more than a certain number of units. You can find out more about the rules in your state by contacting your local housing authority office or by visiting a local law school and reading a copy of your state's statutes.
My lease expires next month, and I plan to move out of the apartment. I heard that the last tenant who moved out had difficulty getting his security deposit back from the landlord. What steps can I take to make sure this doesn't happen to me?
A few unscrupulous landlords make it a policy to not return deposits until the tenant either sues in small claims court or at least shows a willingness to do so. A few others hold deposits of tenants who move out of the local area, knowing they'll have trouble bringing a small claims action. Still other landlords routinely exaggerate damage claims and cleaning expenses. If you took the time to check out your landlord before you moved in, it's unlikely you'll have a problem getting your deposit returned unless you damaged your unit or left before your lease expired. Even so, if you're the least bit concerned about getting your deposit back, you may want to take some precautions. You can arrange a local forwarding address to which the landlord can mail your deposit. You might want to write a short note to let your landlord know you expect your deposit promptly. This puts him on notice that you know your rights and how to enforce them. You should also take colored pictures and a videotape of the apartment when you leave, showing that it's clean and in good condition. Bringing along a friend to view the condition of the apartment is also a good idea, just in case you have to rely on him or her as a witness. If your landlord still doesn't return your security deposit, file a complaint with a local housing authority or take your case to small claims court in order to recover your money.
Another area that can cause problems is subleasing. Most leases prohibit a tenant from subleasing an apartment without written permission from the landlord.
I've been living in my apartment for the last 3.5 years. I haven't had much contact with my landlord during this time, but he seems to be a reasonable person. I just received notice of an opening for a good job in the company headquarters in another city. I still have 6 months before my lease expires, and my friend Rick is interested in moving into my apartment. If Rick agrees to assume all the obligations of the lease, including paying the rent on a monthly basis, can my landlord refuse to accept him?
Probably. Landlords generally have the right to pick the tenants they prefer, subject to federal and state discrimination laws. Your landlord may feel your subtenant is less responsible than you are, even though you remain responsible for the rent if your subtenant doesn't pay. The landlord may be worried about damage to the property. He may also worry about his ability to collect from you if you no longer live there. Also consider this. Your lease should provide that subleasing may not be unreasonably withheld. In some cases, a lease may provide for a subtenant to take your place if you move out. If so, choose a person who's responsible and who'll likely be acceptable to your landlord. Remember, though, if your subtenant violates the terms of your lease, you may be responsible. Similar reasoning applies to bringing in a roommate. Your lease will usually specify who may occupy the apartment. It's the owner's business to know who's using his property. There's a big difference between renting to 2 working women and renting to a group of college students who come and go. If you're going to be splitting the rent with someone, be sure to get that person's name included on the lease. Even so, remember that if both of you sign the lease and one of you leaves or otherwise refuses to pay his or her share of the rent, the other tenant is still responsible for paying the full amount to the landlord. Of course, the remaining tenant can always go to small claims court to try and compel the irresponsible roommate to pay his or her share of the rent.
Another problem can arise if you need to leave before your lease is up. In today's mobile society, it's often necessary to move from city to city because of work or family commitments. Sometimes there's nothing you can do but get out of your lease.
A lease is supposed to protect both you and the landlord. It guarantees you a place to live for a definite period at a set price. It provides the landlord with someone to pay rent for that time. If you leave before the lease is up, you remain responsible for paying rent for the duration of the lease, or until the landlord is able to rent your place to another tenant. But if the landlord can only find a tenant at a lower rent, you are still responsible for the difference, although a few states have limits on the number of months you have to pay for if you move out early. If you think a job transfer or some other circumstance is going to cause you to move before your lease is up, ask your landlord to include an early termination clause in your lease before you sign it. Spell out the circumstances that may require you to move before your lease is up. Many landlords will agree to this kind of clause, although they may require a payment to leave, such as an extra month's rent. This payment is often referred to as liquidated damages. Be sure this damage clause is included in your written agreement. Otherwise, the best way to protect yourself, if you must leave before your lease is up, is to find a new tenant to take your place. Make sure the person has about the same qualifications that you do. Finding your own replacement is usually more effective. In a large building or housing complex, for example, there are always a few apartment vacancies. It can be pretty easy for the landlord to steer tenants to those unleased units and away from yours. Many tenants, of course, don't get pursued for future rent because either they don't leave a forwarding address or they don't appear to have the money to pay a judgment for rent on the unexpired term of their lease.
The opposite of canceling your rental agreement early is the problem of the landlord who wants you out of his property because of some violation of your lease. When this happens, he'll probably begin eviction proceedings.
A tenant who doesn't pay rent, violates other lease terms, or stays after a lease has expired may be evicted. The landlord must follow the law. Each state provides fairly quick procedures to enable owners to recover possession of their property from tenants in these situations. If the landlord doesn't follow these procedures, the tenant may either remain right where he is until they are met or collect damages from the landlord. A typical eviction process begins with a notice to quit, a written demand by the landlord that the tenant pay all rent due, including late fees, within the specified time, usually 3 to 5 days, or leave. If the tenant does neither, the landlord may go to court in order to collect. A hearing will then be held before a judge, and if the landlord wins, the sheriff or police can be called in to remove the tenant and his property from the premises. While the basic process is similar in all states, there are differences that can be important. In some places, courts are backlogged, and eviction hearings can take weeks to be heard, even though they have priority. In other places, there can be a long delay between the hearing and the time when an actual eviction takes place. Some states provide more defenses for non-payment of rent than others. To fight an eviction proceeding, you'll need legal advice and maybe a lawyer to represent you in court. Legal aid lawyers are usually expert in defending tenants. Even if you're not eligible for representation by legal aid, you may be able to get their advice if you're faced with an eviction. Most evictions occur because the tenant doesn't have the money to pay rent when it's due. If you can't make a rent payment on time, tell your landlord immediately. If you've been a good and reliable tenant up until then, he may be willing to give you some extra time to come up with your rental payment. Always try to get any extension in writing. This way you'll have proof that it was granted in case the landlord has second thoughts and begins eviction proceedings anyway. Illegal evictions where the landlord simply changes the locks or removes the tenant's property still occur. If this happens to you, get legal advice immediately. You should eventually be able to collect money damages, and you may even be able to return to the premises, though you probably won't want to. You may be able to get a court injunction against the landlord if you know an illegal eviction's coming and you're still in possession of the premises. Landlords aren't entitled to evict tenants without following correct legal procedures.
Now, here are some short answers to a few of the other basic questions most renters have.
Must the landlord give notice before entering my apartment?
Generally, yes, except in emergencies. You should get reasonable notice before inspections, repairs, and other disturbances. Beware of leases that say otherwise. Terms that give the landlord more right to enter may be illegal, but in any case, they give an indication of the kind of treatment that you can expect as a tenant.
What notice must I give my landlord before leaving?
Read your lease. In most places, you become a month-to-month tenant if you remain after the lease is up. Most leases say you must give a month's written notice even if you move when the lease expires, and some leases automatically renew for an additional term, such as a year, if you don't give notice. If you have an oral month-to-month lease, in many states you must likewise give a month's written notice. If you want to move August 15th, notice by July 15th is usually sufficient. But in some states you're only required to give 10 days notice to end an oral month-to-month lease. You should check the law in your state to see what type of notice is required.
When can the landlord increase my rent?
Again, your lease governs this question. If your lease states that you'll rent your apartment for, say, 1 year at $600 a month, your landlord may not raise the rent during that time. Rent increases are allowed when the lease is up for renewal. With a month-to-month lease, tenants are generally entitled to receive a month's notice from the date the rent is due. For instance, if your rent's due on the 1st of the month, notice of an increase that's given on July 5th wouldn't be effective until September 1st.
Do I need renter's insurance?
It's a good idea and usually not very expensive. Be sure that the renter's insurance policy provides coverage if your possessions suffer fire or water damage or are stolen. Also check to see that the policy protects you if someone's injured in your apartment or elsewhere on the premises because of your negligence. While the landlord's responsible for the overall safety of the building and its systems, you would be responsible if your carelessness led to a fire or someone's injury.
I heard of a case in New Jersey in 1985 where a cockroach embedded itself in a tenant's ear while she was sleeping. The bug had to be removed by an ear, nose, and throat specialist, and the plaintiff had to receive special counseling to overcome her fears. Apparently, the landlord didn't keep his apartments free of cockroaches. He'd spray the kitchen and not the rest of the apartment. Who's responsible for this type of upkeep and other basic repairs?
Generally, your landlord's responsible for basic maintenance and repairs, but read your lease. If the landlord fails to repair something important, despite your repeated requests, many states allow you to have the repair made and deduct the cost from your rent. However, you usually cannot deduct for your own labor.
That's interesting, Judge Wapner, because in the apartment I rent, my bathroom shower has been broken for 3 weeks. I've contacted my landlord twice about the problem, and he still hasn't fixed it. What specifically should I do?
You may be able to have a plumber fix your shower and deduct the cost of the repair from your monthly rent. Before you do this, remember these points. First, check your lease. Many leases specify who's responsible for repairs. Second, if your landlord is responsible, be sure to send a written notice of a need for the repair. It's a good idea to send it by registered mail and keep a copy of it as well. Third, if the problem still isn't corrected, hire a plumber to fix the shower and send a copy of the bill to your landlord. If he refuses to pay, then you may be able to deduct the cost from your next month's rent. You may want to get a lawyer's advice before making repairs and deducting money from the rent payment, as it could lead to an eviction attempt by the landlord. Keep in mind that when a landlord does do work on his property, he must do it in a safe manner. There was a case in Massachusetts a few years ago involving a landlord who left some scaffolding on the property after dark. A tenant, not knowing the scaffolding was there, tripped on it at night and suffered a debilitating back injury. The jury found the landlord guilty of negligence and awarded the plaintiff over $100,000.
There are a lot of code violations in our building. I tried to get a tenant group together to force the landlord to fix up the place. Didn't have much luck because the other renters were worried about retaliatory eviction. What's that?
When a landlord tries to evict you because you assert your rights, report a building code violation, organize a tenants organization, or otherwise cause trouble, it's called retaliatory eviction. In simple terms, the landlord's getting even with you for creating problems. You'll want legal representation when you're faced with an eviction.
What should I do if my apartment becomes uninhabitable?
It depends. If the condition's more than a temporary power outage, it'll probably enable you to break your lease and move. And if the condition was deliberately caused by the landlord, it may mean you can sue for retaliatory eviction. If you stay, you may not have to pay rent while the condition continues, or you may owe reduced rent. Utility cutoffs, lack of heat, overpowering odors, broken plumbing or broken windows, and other unsafe conditions of all kinds may or may not violate the landlord's implied warranty of habitability, which is the legal term describing the landlord's obligation to keep his property livable. Laws vary from state to state, so be sure to get legal advice or check your state laws.
My sister was turned down for an apartment because she's a single parent with 3 children. She has a good job and can easily afford the rent. Isn't discrimination illegal?
Certain forms are. Federal law prohibits discrimination on the basis of race, religion, sex, or national origin. But these laws don't apply to a small landlord, and they may not protect a parent with small children. Most states have their own laws that expand on the federal protections, but they vary a great deal.
Buying a home is by far the most expensive and most complex transaction most of us ever undertake. Much of the complexity could be removed if it were not for entrenched interests that profit from our expensive and out-of-date system for transferring real estate ownership. Anyone who's bought a house remembers that long list of fees to be paid for one sort of service or another, and how many pieces of paper must be signed. Our system has its roots in medieval England, where land was the source of most wealth. But it continues today because real estate agents, lawyers, brokers, appraisers, inspectors, lenders, and governments all profit from it.
Improvements are occurring, but at a snail's pace. The real estate industry is creative at adding new complexities when the old ones are threatened. Compare the purchase price of a vehicle with that of a house. Many cars sell today for the same price we paid for houses a few years ago. So the amount of money involved can't account for the complexity of the home sale. Both purchases usually involve financing. And while the home loan is for a longer term, the security is better. Cars are mobile, wear out quickly, and are often damaged. Now, understanding that the system is unwieldy and illogical may not make the process of buying a house any easier, but it should put you on your guard. You need to do your homework at every stage of buying real estate. Pay particular attention to your financing. Once you and the lender have both agreed to the terms of financing, make sure that the lender doesn't change the terms or conditions by adding fees or coming up with new requirements. Carelessness and delays can be even bigger problems. The volume of paperwork involved in buying a home is incredible, and mistakes can occur. Don't depend solely on others. Be sure to stay on top of the process yourself. Real estate agents can be your best allies. They usually don't get a dime until the deal goes through, and while they technically work for the seller, it's in their own best interest to get the transaction completed quickly.
First-time buyers have at least one consolation. They don't have to worry about selling their old home. Selling an old home at the same time you're buying a new home means twice as much work.
My husband and I are looking to buy a home. We've looked at dozens of possibilities, and finally we've found one that both of us really like. It's a charming old colonial house in a great neighborhood. I'm concerned, though. I'm wary of all the steps in buying and financing this purchase. And in our particular case, I want to be sure that everything in the house is in working order. How can I make sure that we're not paying for a house that may have structural defects or major problems?
There are multiple steps involved in buying a new home, one of which is making sure it's in good working order. To ensure the home's in good condition, it makes sense to have someone inspect the house, including any adjacent land, any outdoor wells, and other necessary structures. If you discover any problems, you should discuss them with the seller and ask him or her to fix them. If you plan on signing the purchase and sale agreement, be sure to include these repairs as a condition of the ultimate sale.
An overview of the process is this. Buying a house is basically simple. It's the details that can drive you crazy. You find a place you like, make a written offer, haggle a little, reach an agreement, and make a small deposit. Shortly thereafter, you and the seller sign a longer contract that says what goes with the house, when inspections will happen, who'll remedy any defects, what loan terms you need, and when the transfer of ownership will take place. In the meantime, your deposit's held by a third party. In some states, that party's called an escrow holder. You get your loan, then you, the seller, and the closing officer all meet and exchange documents and checks. You move in and, just like in the fairy tales, live happily ever after.
While that's the overview, I want to take a couple of minutes here to add a little detail to the broad picture. Let's look at some of the players in the process and a few areas where problems most often occur. First, the agents. Real estate agents work for the seller unless you have hired and are directly paying a buyer's broker. That may be a good idea, but it's still fairly uncommon. Often potential buyers assume that an agent they've contacted and who then takes them to see a house is their agent. They believe that the agent who lists the house is working for the seller. That's logical, all right, but it's wrong. Both agents work for the seller. In the usual case, they'll split the commission for the sale, which is paid by the seller. The agent who finds you the house is called the selling agent. The one that the seller signed up with is the listing agent. I'll say more about agents later on, but I want you to remember that they both work for the seller. This means that you should be very careful about revealing too much to either agent about your finances or about anything else that could affect the price or terms of the deal. While the selling agent's main interest is selling you the property, he or she is also bound to try and get the seller the highest price and the best terms possible. If you make an offer but let the selling agent know that you're willing to go higher, you can be assured that the information will be passed on to the seller.